The coins alert is where everything in this video comes from. Also, don't forget to like and subscribe to my station to get more XRP news and news about cryptocurrencies in general. Look at this now. Ripple vs. CC case will be put on hold. The court gives SECC until January to give its final reports before we move on. There is a new crypto airdrop going on right now on Telegram and it will start soon. Make sure that you take part in this airdrop. Just below the movie there is a link. Do not miss this. Let's watch more of our movie. It was a notice of appeal in the XRP finding that the Securities and Exchange Commission sent to Judge Torres to question his decision that XRP is not a security. With a new cross appeal, Ripple gave the SEC a problem to solve. At first, the regulatory group missed the deadline for a new appeal, but they did so by sending in a Form C after the fact. The last reports from the Securities and Exchange Commission are due in January. For starters, the U.S. Securities and Exchange Commission SEC missed the deadline to be specific about its objections. However, it has kept up its appeal in the lawsuit it has made against Ripple. Right away, Ripple sent back a cross appeal saying it would not leave anything out in its case. The company has not been stopped by this, though. The court gave the SEC until January 31st to do something. The Securities and Exchange Commission has been given a strict order by the U.S. Court of Appeals for the Second Circuit. It must present its final points by January 15th, 2025. These rules were made after the SEC was given a deadline. After that, the court will decide whether to throw out the case completely or keep some parts of it going. The court's decision, the United States Court has given the Securities and Exchange Commission until January to turn in its final report. Supreme Court of the United States for the Second Circuit. After a long court battle with heated arguments and confrontations over evidence, this important action was taken. The court battle was about the legality of XRP and the SEC's authority to enforce securities laws in the cryptocurrency business. It has always been the stance of Ripple's lawyers that the SEC's approach is unclear and that XRP does not meet the usual definition of a security. In its appeal, Ripple is questioning 4 of the SEC's most important points. These questions include whether or not an investment contract is legally binding, how to classify sales of XRP by institutions, the fair notice defense, and the legality of the injunction. The Ripple Form C was filed and Ripple was given credit for it. Officials from the United States Court said that both Brad Garlinghouse, CEO of Ripple, and Ewart Alderati, Chief Legal Officer, are confident that they will be able to win the case. People who disagree with the SEC say that their case is very weak, especially since the court has already said that XRP is not a security. The Securities and Exchange Commission (SEC), on the other hand, recently asked for more time to file its major brief, which has made people question the agency's trustworthiness. Based on this new information, it looks like the Securities and Exchange Commission (SEC) is having trouble coming up with a strong reason to back its appeal. Even though they were given extra time, the Securities and Exchange Commission (SEC) did not file their complaints with the Second Circuit Court by October 16th. What happened made people feel both confused and hopeful. This is not like this to happen. Because of this new development, people became even more suspicious that the agency might be getting closer to settling with Ripple. On the other hand, those hopes were quickly dashed. The Securities and Exchange Commission sent in its Form CU on Thursday, October 17th. This explained why it was appealing and most likely put the case off until year 25. Sales of XRP that are automated on sites for trading digital assets. XRP was given to Ripple workers and the executives of the company are said to have helped with these sales. These are all things that have been thought about. This ruling by Judge Torres that these actions do not break securities laws is being questioned by the Securities and Exchange Commission (CB). It's important to note that the Securities and Exchange Commission is not questioning Judge Torres' decision to refuse Ripple's disgorgement or the $125 million fine she gave them. The government body is instead focusing on making a rule that will allow it to police similar acts in the future. Since the appeal was officially filed, the case is likely to drag on for a long time, leaving people in the cryptocurrency industry unsure of what will happen next. What Ripple's leader said in reaction. A quick answer has been received from Ripple's top managers. Because the SEC filed their report late. Because they didn't agree with what the government did, they said it was making up rules as it went along. Brad Garlinghouse, the CEO of Ripple, didn't mince words when he said that the SEC's appeal is going as it should for a body that makes up rules as it goes along. In response, Stuart Alderode, Ripple's chief legal officer, used a calmer voice but still made it clear that the court's previous order is still in effect. It's not a surprise at all. It has been made very clear once more. The people involved are not appealing the court's ruling that XRP is not a security. This choice must be followed because it is the law of the land. The following week is when Ripple's Form C is supposed to be filed. The SEC wasn't met by the due date. It was time for the Securities and Exchange Commission to turn in Form C and D. She had to do it within 14 days, and the due date was October 16th. The date did not get pushed back on Monday, October 14th, because of the Columbus Day holiday, despite what was said. Sundays and holidays are not counted as work days when it comes to court deadlines, unless the court is told otherwise. The Securities and Exchange Commission SEC missed this important date, even though it was on time for every other file. To appeal the court's ruling, you need to fill out Form C. If the request is not sent in within the time limit, it may be turned down. There is some doubt about the exact date of the deadline, though, because in some court systems, the SEC's notice was filed on October 4th. Some people think the date is October 18th. Timeline was updated. Once both sides agree on a briefing plan, the Securities and Exchange Commission SEC will have 90 days to send in its legal brief. This brief will explain why the Commission disagrees with Judge Torres' decision. After this, Ripple will be able to reply and send in its brief, setting the stage for a long court battle that could last until July 2025. Another important thing to keep in mind is that the Securities and Exchange Commission has not yet said which parts of Judge Torres' order it will review. Not until today, when Form C is filed, will these details become clear. Authorities in the law think that the appeal court's decision could come as early as 2026. Even so, there is still a chance of a deal, especially if the government supports cryptocurrency ownership. Some people who are excited about XRP think that a settlement is more likely to happen while Trump is in office because Trump is thought to be friendly toward cryptocurrency. Many people are still not sure how long this legal battle will last and how it will end, because it depends on what both sides do and what the appeal court decides. The information given is not meant to be taken as trade advice. Any purchases made based on the information on this page are not the responsibility of the people who made them. Before making any investment decisions, you should definitely do your own study and talk to a professional who knows what they're talking about.